Good evening, everyone. I'm Aswini Weereratne, and this is the third in Doughty Street Chambers series looking at the proposals in the new mental health bill. Today, we're looking at changes to the powers of the Mental Health Tribunal. While the bill has yet to pass and remains in the Commons report stage, it's nearly at the end of its legislative road. There'll be a third reading before the final stages are reached and then royal assent. Now, we all know that mental health tribunals are an essential independent judicial safeguard for patients detained against their will. It's worth noting that the mental health tribunal related changes have been largely uncontentious as they went through Parliament, and so will probably become law. And there's been no substantive amendment to these particular proposals. However, there is inevitably real concern about, firstly, the resourcing, training and capacity of those involved with the tribunal processes to cope with the likely increased work. Secondly, whether there will be appropriate use of the new power to conditionally discharge a restricted patient into conditions amounting to a dole. And additionally, the availability of resources essentially runs through it all. Now, by way of quick summary, the key tribunal-related changes that I wanted to highlight are, firstly, by clause 7, the new admission and discharge criteria are now to be aligned for sections 2, 3, and CTO patients. Of course, detention criteria are also being amended, so we might ask whether this raises the bar for discharges or simply aligns to practice already in place through the old now case of RH from 2001. Clause 30 deals with periods within which a patient may apply for a tribunal, and these are being amended. This could be important if access to a speedy review is at stake under Article 5.4 of the Convention. Now, mandatory references to tribunals are set to become automatic after a certain period has expired. That's clause 31. And by clauses 32 and 33, these introduce a big change, permitting the tribunal to conditionally discharge a restricted patient with a condition amounting to a deprivation of liberty. And this aligns with a new duty on the Secretary of State to refer the patient to the tribunal at intervals. The Secretary of State may also impose dole conditions on restricted patients, and that's clause 35. Questions there might be, are there proper safeguards for patients in these circumstances? And what are the implications of a retrospective operation of these provisions? The tribunal may recommend reconsideration of CTO conditions. That's a new section 72(3)(b), and relevant to the Supreme Court decision in PJ and Welsh Ministers, which held that no dole conditions could be placed in a CTO, and also noted no power at that point in the tribunal to do anything about it. So this appears to try and remedy that. Now, on aftercare, there are two changes relevant for us today. There is to be a statutory power to recommend that responsible bodies make plans for aftercare services to be added to section 72(3), that's by clause 46. And on aftercare under section 117, the commissioning bodies must jointly give notice in writing if they are satisfied that the patient no longer needs services, and there are new deeming rules to decide who the relevant responsible bodies are when the patient moves from one area into hospital and then is discharged into another area. So inevitably, as I've said, questions around administrative burden or cost and resources will run through the whole lot of amendments. Now, the running order, we will have Liz Cleaver, who will give you some thoughts around the changes that I've just mentioned. Zoe Mears, who will deal with the impact of these changes on trusts and trust practice. And Sophie Miles, who will talk about the possible new arguments that might arise before the tribunal. And at the end, there'll be a Q&A that we will try and manage. And I'm going to encourage you all, please, to pop your questions into the Q&A box at the bottom of the window. Now, I'm just going to introduce the three speakers briefly. Liz is a barrister in our Court of Protection and Mental Health team here at Doughty Street. She also has an inquest practice, And before transferring to the bar 18 months ago, she was a solicitor for 11 years, specialising in mental health, court of protection and public law. Zoe Mears has over 30 years of experience of working in health and social care, predominantly in adult mental health services. She's also worked with adults with autism, learning disabilities, and with rough sleepers. She qualified as a social worker in 2002, and she currently works as the head of social work, safeguarding and mental health law for South West London and St George's NHS Trust in London. Now, Zoe practiced for a decade as an AMP, ASW of old, and was a lead for a London borough. She was appointed to the Mental Health Tribunal as a specialist member in 2012. And then Sophie Miles practices in all aspects of mental health and disability law. A busy court of protection practice includes personal welfare, international adult protection, medical treatment and property cases, as well as challenges against deprivation of liberty authorisations. She acts for vulnerable adults, children, their families, local authorities and NHS bodies. She advises in all areas of mental health law, and her long experience as a mental health solicitor before coming to the bar gives her practical understanding of these issues. She was appointed as a fee-paid member of the Mental Health Tribunal in 2004 and nominated to sit in the Court of Protection in 2020. She co-authored Legal Action Group's Mental Health Law Review Tribunal Handbook, published in 2015 and with a forthcoming second edition out next year. Now, with that, I'm going to hand you over to Liz Cleaver. Liz, thank you. Off you go.
Thank you very much, Aswini, and thank you everyone for joining us this evening for this webinar. We've got some great attendance again, so thank you all very much for joining. So I'm just going to share my slides, and I think I have. There we go. Okay, so I'm going to talk specifically about the new powers relating to deprivation of liberty and supervised community discharges, which is going to be a really important new power that the Mental Health Tribunal will have for restricted patients. So just very briefly, in terms of what the changes are to mental health tribunals that we're going to see in the bill. So there's going to be, really importantly for patients, an increased access to the tribunal via some additional rights to apply and also additional automatic references to the tribunal. There's going to be some changes to the detention criteria, which Sophie will talk about a bit later, and therefore also changes to the legal tests that the tribunal is going to be applying. There are going to be new powers, so new powers for statutory recommendations for unrestricted patients, so recommendations related to aftercare planning and also, as Winnie mentioned, in relation to CTO conditions as well. And fourthly, this really important new power to discharge restricted patients to conditions that amount to a deprivation of liberty. So those are going to be known as a supervised community discharge. And it's on that final point that I'm going to focus. So supervised community discharge. Why is this important? So the issue is that some forensic patients, having spent sometimes many years in hospital receiving treatment, still pose a risk, particular risk to others, when they are approaching discharge from hospital. And this was an issue that arose in the case of What do we do with this group of patients who still need that additional supervision in the community when they are approaching discharge from hospital? What is the extent of the legal powers in that situation to authorise a deprivation of liberty if that is going to be needed in the community, and what are the powers of the tribunal around that? So a little bit of a reminder about the decision in MM. So MM was a gentleman who was in hospital under Section 3741. He was an autistic gentleman, also with a learning disability, and he'd spent many decades in hospital following a conviction for arson in 2001. So apart from a fairly brief period when he was out of hospital in 2006, 2007, he had been detained through this time. Now that the tribunal had access, the first-tier tribunal had access to some expert evidence which said that MM could be discharged from hospital if there was a suitable care plan in the community. But importantly, that care plan would involve restrictions, including supervision and monitoring. And one can read into that essentially he wouldn't be able to have unsupervised access to the community. He would probably need one-to-one support in the community, and that would amount to a deprivation of his liberty. Now, the reason this was an issue in terms of legal framework partly was that MM had capacity to consent to the restrictions, and presumably had capacity, therefore, to consent to his care plan and to the proposed placement in the community. This wasn't going to be a case where the Mental Capacity Act could come into play and authorise or provide that legal framework for the restrictions. So that was the difficulty. The difficulty was MM is going to need to be deprived of his liberty in the community. We can't do that under the Mental Capacity Act. What is the framework? Can the tribunal authorise conditions of discharge that would actually amount to a deprivation of his liberty in the community? So that was the question. Would it be lawful to discharge him subject to the deprivation of liberty, and can he validly consent to the conditions, having agreed that he has capacity to do so? And there were quite a number of practical issues that were then debated in the Supreme Court around this. So would MM really be validly consenting to restrictions, or is it really that he's desperate to get out of hospital and he will just accept the care plan that is given to him? Is there really a choice if it's going to be hospital or being in the community with the level of restrictions? And also what happens if he then withdraws his consent to those conditions? And so the Supreme Court was asked to review all of this and look at what the powers are for the tribunal in that situation. And the Supreme Court found that the Mental Health Act doesn't provide an express power for detention of conditionally discharged patients. And as I've quoted Lady Hell there from the judgment, so there's no equivalent express power to convey a conditionally discharged restricted patient to a place where he is required to live, or to detain him there. And if the Mental Health Act had contemplated there would be such a patient that could be detained, it's inconceivable that equivalent provision would not have been made for that purpose. So if there's no specific provision within the Mental Health Act authorising the tribunal to have this power, then we can't read that power into the Mental Health Act. So essentially, we then ended up with a gap in legal framework for this particular group of patients who need those restrictions in the community, but those can't be authorised by the tribunal, and they can't be authorised under the Mental Capacity Act because they have capacity to consent to those conditions, and therefore they would not fall within scope of the Mental Capacity Act. So this was looked at by the Independent Review of the Mental Health Act, who recommended that there should be, so the government should legislate to give the tribunal the power to discharge patients with conditions that restrict their liberty. So that was one of the issues that was to be addressed in the Mental Health Bill and has now been addressed in the bill. And in the meantime, what has actually been happening is that the Secretary of State issued guidance that suggested that this group of patients could go on long-term Section 17 leave. So they've effectively living in the community under these restrictions, but they haven't yet been conditionally discharged pending the gap in this legal framework effectively being filled. So the answer to this issue within the Mental Health Bill is clause 32, which provides a new mental health tribunal power to discharge subject conditions amounting to deprivation of liberty where, and there's two conditions, sort of quite a strict test in place there that is going to need to be applied. So the first is that the conditions amounting to a deprivation of liberty are necessary for the protection of another person from serious harm while the patient remains discharged from hospital. And two, that for the patient to remain discharged subject to those conditions would be no less beneficial to their mental health than for them to be recalled to hospital. So effectively, my reading of the second point there is that there doesn't still need to be less restriction than there would be in a mental health unit setting. And there's also going to be, say, under clause 35, a power for the Secretary of State to impose a condition that amounts to deprivation of liberty. Again, there's going to be a strict test to be applied for that. So conditions amounting to a deprivation of liberty can only be imposed by Secretary of State if he or she is satisfied that those conditions are necessary for the protection of the public from serious harm. So question mark there whether the threshold for the Secretary of State imposing a condition that amounts to deprivation of liberty is actually slightly lower than that for the tribunal, who have to apply that two-limb test before applying those conditions. So what are the numbers? So there's been some discussion in committee about really, in reality, how many patients are going to be affected by this change. And Stephen Kinnock was asked about this in one of the committee meetings and suggested that it's only going to be relevant to less than 1% of mental health tribunal hearings. But if that is the case, I sort of did some maths really to look at how many that would be. We're still looking at about 168 hearings per year, and we're also looking at a group of restricted patients that is still growing. So as of the end of 2024, we had 7,921 restricted patients, of which slightly more of them are in hospital, but there's still a significant number who are on conditional discharges as well. So it's not a tiny population of patients who are going to be concerned potentially by this change. It will still be a notable number of hearings per year that are potentially going to be considering these new powers. So what is the impact likely to be of this change? And one of the debates that's been had around this is there a risk of overusing this power? So the intention really is to address what is intended to be quite a small loophole really within a small gap currently in legislative provision for this particular group of patients who are potentially very stuck in hospital and can't be discharged because of this, the lack of availability for legal framework for their deprivation of liberty. But is there actually a risk that we're going to be using this power for other groups of restricted patients as well? And one of the concerns is that, well, when community treatment orders were brought in, again, those were aimed at addressing a minority of patients who were seen as revolving door patients and to address readmission rates for that group. And we know that community treatment orders have actually been used a lot more than was anticipated when they were brought in further to the amendments to the Act in 2007. So that's the first concern. Are we actually going to be overusing these supervised community discharges and bringing in restrictions for patients who previously wouldn't have had the deprivation of liberty authorised in the community? Also, is there a risk of racial disparities? As we know there has been with community treatment orders, people from ethnic minority backgrounds are much more likely to be placed on a community treatment order. And that was an issue that was raised by the Royal College of Psychiatrists in the consultations around this bill, and also by the Joint Committee on Human Rights. And coming back to the issues around racial disparities, the Joint Committee on Human Rights reported in again in May 2025, and they expressed some surprise that the mental health bill doesn't contain any measures that directly address the racial and ethnic inequalities, and they wanted inclusion of that in the bill. And Mind has also called for there to be further guidance on the use of the supervised community discharge power. So seeking a bit more guidance and possible reassurance, really, that these powers, which are really significant to authorise a deprivation of liberty in the community, are only going to be used where that's absolutely necessary to fill that gap in legislative provision that I have mentioned. Other concerns, again, I mean, resourcing, that's been a concern throughout really all of the discussions around this bill. And there's going to be a need for further clinical assessment of risk. There's going to need to be legal input into consideration around conditions amounting to deprivation of liberty. So has that all been factored in really into the change? Also considering what this might mean for the interaction with mental capacity legislation. There was some discussion in the committee about liberty protection safeguards. Remember those that have been shelved. We don't know whether they're coming back at some point. So if they do come back, there's going to be a need for some coherence between across the mental health and capacity jurisdictions. So again, it raises the questions about the interface between these two legal frameworks. And for me, considering that, also raises the question about whether supervised community discharges might also be used for patients who lack capacity to make decisions about their discharge conditions or their care arrangements upon discharge. And that was not the intention initially of this change to the legislation, where we still have the Mental Capacity Act that is an available framework for this group of patients. Also, the concern already mentioned that this provision will apply retrospectively, so it's going to be available for all patients who, regardless of when their restriction order began. So for some patients who are still stuck in hospital, that might be good news that there's going to be a change that ends that position. But could there be possible legal challenges in individual cases where a patient has faced this scenario when they potentially were not expecting to be subject to supervised community discharge? And the government has confirmed that the CQC will be involved in the supervision of some of the implementation of supervised community discharges. So those are the main points I wanted to cover. What I forgot to do is to thank our second sixth pupil, Jordan, who really helped us with the research for this seminar. So just a quick shout out to him, and then I will hand over to Zoe.
Thank you. And thank you for inviting me this evening to join this webinar. I was wanting to look at some of the potential impacts of the changes that are proposed in the bill to the safeguards that are provided through the tribunals. I'm just going to share my screen now. Thank you. Okay. Okay. Is that showing full screen now? Can I check with somebody? Thank you. What I see is sometimes different.
So it's not yet, no.
Oh, is it still not showing slideshow?
Yeah, no, not quite yet.
Misbehaving.
Try.
It's moving at least. How about now? Does that look better?
Yes, you've got it.
Brilliant. Thank you. Apologies for that. Okay, so thinking about some of these implications, well, what's the rationale for the changes anyway? What's this all about? Well, the most important thing is the impact that these tribunal safeguards have for people in benefiting the promotion of their dignity and human rights. It's an increased legal safeguard that should align with the broader goals of improving patient rights, transparency and accountability within the mental health care settings through what? Well, increased oversight, more regular reviews of detention and the justifications for those restrictions that amount to a deprivation. Improved rights of access for patients who are empowered to challenge their detentions, and they'll be more cool at looking at things that bring about that detention and what is within their care and treatment plan. The improved equity of access and fairness, reducing the risks of unjustified and unequal treatment, aligning with the patient and carer racial equality framework, as we know, one of the big drives behind the changes that brought about this bill, thinking about those racial disparities that Liz was just speaking of. Legal safeguards, of course. The tribunals are independent and they act to scrutinise and check for any potential overuse or unnecessary detention. And of course, the increased systems accountability, external oversight of the clinical decision-making, the ability for the tribunals to look at the care and treatment plans that are being proposed that should be co-produced with the patient. Has that happened? Has the carer been included too? Those are the kinds of scrutinies that the tribunal is going to be able to bring. And of course, then the expanded powers of the tribunal to facilitate that patient discharge and include oversight of aftercare services, both 117 and otherwise. And the whole point of this is to be recovery oriented, is for the tribunals to look at these reviews and encourage clinicians to think about a person's progress within the clinical setting, what restrictions can be reduced, and how we can help patients move to greater autonomy, whether it is within the context of them contributing to their care and treatment plans, or less restrictive alternatives that might lead to their ability to leave an inpatient setting. So what are these increases that I'm speaking about? Well, we can see under CTO, Section 3 and Part 3 for some restricted, there is a shift in how soon patients will be reviewed and give rise to periods of them being able to initiate their own appeal to the tribunals. So we're moving from the initial 6-month period under Section 3 to a 3-month period, which will be a delight for many people. Having to spend years telling people the outcome of assessments where we are going to remove somebody's liberty and explain that they can be held for up to 6 months, but it won't be for any longer than they absolutely need to be there, and a tribunal could come in to check that, doesn't really get heard in the round. What people hear is 6 months, and that is very damaging to individuals who perhaps have never entered the mental health systems as an inpatient previously, and what that means for them. There's still a lot of fear that it can impact on things like the ability to gain a visa to go abroad. It can't, in fact, it might affect insurance, but it can't affect your ability to travel. But these sorts of myths have gone around for many years and bring around stigma and fear within the context. So being able to say that it's a reduced period of initially 3 months, I think will be really welcomed by all. The second period will then be for the next 6 months, then at 12 months, and then annually. So you can see that within the first year of someone's detention period, not only will it be reviewed twice, but there will be 2 review periods in which they can apply to the tribunals for them to take a note of it and decide whether the criteria is applicable or not. There's no substantial changes for CTO. And again, it remains the same for Part 3. So what about those ones that automated and referred on the person's behalf? Well, for Section 3, again, we're seeing the reduced period where it will be for a first 4-month period. So somebody who hasn't applied to the tribunal themselves within 3 months, there'll be an automatic reference by the hospital managers before the end of the 4-month period, and then again at 12 and annually. So that's an increase again of an additional hearing period. Again, for the first 6-month period of CTO, that remains the same. But what we see now for automatic referrals is a significant increase, that it will be at the first 12-month period and then annually, whereas previously it was only annually for children and 3 yearly for adults. So it will be for all ages now that it moves to annually. And Part 3, again, it was every 3 years, and that will be moving to annually for automatic references as well. It's a significant difference, isn't it, between being heard 3 times in 3 years to once in 3 years. So we welcome this. But what does it mean in real terms for a resource implication? Well, the government did an impact assessment, and this was last issued on the November of last year at the final stage of the costings. It was estimated that the costs will be around 5.3 billion, and that includes the range of things that the bill will impact upon, including housing, health, and social care costs. 313 million of those costs will be going to the judicial system, and that's at the values of last year. So what does that mean in England? Well, 1.9 billion of the costs will go for the NHS additional resourcing and requirements. 396 million of the costs will go to the local authority. It's unclear whether these have all been costed out in completeness. 2.5 billion will go towards housing, which includes some of the care-related costs for the reforms that will be required in order to be able to provide the services people with learning disabilities and or autism require, but currently we see are often in long stay inpatient beds because there isn't an alternative for them to move to. We will see slowly the resources coming to enable people to move out of those psychiatric settings and into more community settings. And 78 million of the cost for the CQC, which will include the increase in SOADs. 287 million of the costs will be going to the tribunals, and that's for the bit that we're looking at specifically today. So the impact assessment that was done by the Department of Health and Social Care showed that we have just over 52,500 detentions in England, and of that 5,618 were CTOs. They currently receive, the tribunals that is, between 20 and 25,000 hearings annually based on historic data. And so what they have looked at is the projected post-implementation changes. What will that mean? Well, they believe it will bring about that a rise of costs of 287 million. And that will include the additional requirements for legal aid, because obviously every patient has the right to be represented. And this has been looked at over a sort of a 20-year projection, where automatic referrals are likely to cost 219 million, which is the larger cost driver, and where treatment and choice expanded powers, which Sophie will talk about a bit more in a minute, is 70 million. So the projected, well, they have projected that the annual increase between 2031-32, when it's considered it will be coming in entirety, will be about 30 to 40% uplift in hearings, translating to 6,000 to 8,000 additional hearings a year in England. So the automatic referrals and the increases in patient-initiated applications, which we've just been through, will include the ability to look, of course, at those expanded powers. I work, as you know, for a London trust, and we decided to look at that against our population cohort and see how that translated to us in real terms. So we assumed that we handle about 2 to 3% of the population based on our population being just over 100 million, as you can see. And we projected that this would mean, based on our average amount, so we looked at a range between the years of 2019 pre-pandemic and last year post-pandemic, because we saw a peak and a fall within the period of our COVID pandemic in terms of hearings, and we're back to the baseline of the amount of hearings we tend to have on an annual basis, and that is 330 a year. I'm just willing to move my bar. Excuse me for a second. Okay. So what does that mean in real terms for us? Well, that means that we're going to need to ensure that we have available the range of staff required to support patients to attend an additional 100 to 132 additional hearings a year post-implementation. And therefore, for us, it does work out as a trust, it's exactly 30–40% increase, as in line with the National Impact Assessment. So I wanted to translate this a bit further and think about, okay, so but if that's the numbers, what does that mean for us? So we started to look at the place where it was easiest to go to first off, and that was the impacts it's going to have on our mental health law office and administrators who administer all of the statutory documents and administer any request for a tribunal to be sent from the patient onto the tribunals, and then setting up the hearings and facilitating the reports being sent. Now, what I just wanted to note was not all of the things that we'll be doing are necessarily mandated for. So there's likely to be an increase at the same time for the tribunals as hearings for the hospital managers. They're often done by what's called the associate hospital managers in a panel of at least 3, and they hear things as an automatic reference at certain points of people's detentions. We've seen the increased rates of frequencies of hearings for section 3, section CTO, and some of the forensics. That will therefore increase the numbers as well for AHMs. So this is just specifically to the tribunals. So we made a key assumption based on a review that had been done previously, looking at the workload of a mental health law office in both South West London and Slough, where we had recognised that the time to prepare and coordinate and follow up to set up a mental health tribunal is about 4 to 5 hours of admin time. We have 9 full-time workers doing that, and currently there is 1,755 hours required per month, which excludes their periods of leave. So what happens if the low scenario of 30% increases occur? Well, looking at that, we'll need an extra resource to cover those 445 hours a year. And if it's at the top end, nearer 600 hours. And that will equate to the requirement for about 2 further full-time staff in order to service that additional amount. So you can see just in one small area of what we do, the increase of what is going to be required to ensure those safeguards for our patients can happen effectively. So I just wanted to move into my last slide with you today, thinking about the changes in relation to aftercare and what I would like to bring to your attention as seeing as a very positive thing. Obviously, we've heard about this. It's to give the tribunal a new recommendation for the responsible bodies, i.e. the local authority and the integrated care board, where the person had ordinary residence in the meaning of the Children Act or the Care Act, to consider making plans for aftercare to be made available for a patient to facilitate their discharge at a future date. The new power under section 72(8) will be to provide the definition of aftercare that follows the same definition of that of section 117 of the Act, so it applies equally to those under section 2s, etc. And the power for the tribunal to reconvene to consider if a patient's case has a recommendation that has been complied with or not through this new power is really, really beneficial. Could it make difference in real terms? Well, I genuinely think it can. Thinking about scenarios of people, particularly it can be in acute settings, but in particularly in the sort of national and forensic services, so the eating disorders, rehab services, deaf services, forensics, we often find that patients are not within the area where they originate from, who will have responsibility for their aftercare arrangements. It can be very challenging in order to engage those local authorities and integrated care boards, especially if they're not from the same area, because currently not all the law is in step, which this reform is helping to do. The problem being that at the moment as a tribunal, when we hear the case, we have limited powers as to what to do if we're not getting the information we need about the person's aftercare arrangements that might prohibit our ability to move forward to thinking genuinely about the discharge. If we're hearing from a multidisciplinary team evidence that they feel that somebody, for example, needs to have a period of step down under Section 17 so that they can move towards the aftercare to make sure that it's the right aftercare for them, etc., etc., we can sometimes find as a tribunal panel getting our arms somewhat bound by it and finding ourselves coming back to hear evidence again that might not be necessarily about the criteria in the same way as usual. So what this will enable us to do as a panel is call the right people to account to come and talk to us. At the moment, we tend to call back the responsible authority, i.e. the hospital, and they often can't answer for it because they're not the ones responsible for making the aftercare arrangements. These new provisions will enable the Mental Health Tribunal to ensure that they can call in the responsible authorities, which are the local authority and the ICB themselves. Thank you. That's all of my slides. I'm going to hand over to Sophie now, and we'll take a Q&A at the end.
Thank you very much, Zoe. I'm now going to share my slides. Great. Can everyone see them properly? Thank you very much, Zoe. So in this set of slides, I'm going to try and anticipate the kind of arguments that might come before the Mental Health Tribunal after the bill takes effect. And I just thought I'd start by sort of stepping back a little bit and thinking about, you know, what is the tribunal supposed to do? And is it doing it? Is it doing what it says on the tin? And as Winnie said it right at the start, you know, it's an essential legal safeguard. And that's been emphasised recently by a European case just this year, Spivak and Ukraine, which just talks about the importance of when compulsory medical measures are taking place, the need for rigorous oversight to ensure that the interference with personal autonomy is proportionate and justified. And the court in that case went on to say how important it is to establish that any treatment being provided is both appropriate and necessary. So that's just really a reminder of how important a safeguard the tribunal is. And it's not really doing kind of what it says on the tin if it's not covering all these aspects that this case has identified. So let's have a look at what the tribunal might look like if all these changes come into effect, and what sort of arguments might be made that perhaps will be different to the kind of arguments the tribunal hears today. I think a lot of those arguments derive from the changes to the criteria for detention. And again, as Aswini says, the tribunal, the powers for the tribunal, the circumstances in which the tribunal has to discharge a patient mirror the detention criteria. So what's changing in the detention criteria that's going to sort of play through to the arguments in the tribunal? I think there are three key areas. Firstly, the exclusion of learning disability and autism for sections other than Section 2, then the new serious harm test, and then the therapeutic benefit test. And we'll have a quick look at all of those. So just sort of starting off to remind ourselves of some of the new definitions that are going to be in place, assuming all the provisions of the bill go through. So the bill defines learning disability and autism, the definitions on the screen there, nothing particularly controversial then. But then we've got a new disorder called a psychiatric disorder, and a psychiatric disorder is anything other than a learning disability and autism. And we've also got a definition about serious behavioural consequences to learning disability, and that essentially means a learning disability that's associated with abnormally aggressive or seriously irresponsible conduct. So let's look at how these apply to the proposed new criteria for admission. So Section 2. In order for someone to be detained under Section 2, there's got to be a mental disorder of a nature or degree warranting detention. So that includes all mental disorders, including those with learning disabilities or autism. But then there's a change. So the next limb that's got to be satisfied is that it must be the case that serious harm may be caused to the health or safety of the patient or another person unless they're detained, and given the nature, degree and likelihood of that harm and how soon it would occur, the patient ought to be detained. So that's Section 2. Section 3, the patient must be suffering from a psychiatric disorder. So no more people, theoretically, once this comes into force, with autism or learning disability being detained under Civil Section 3. So that psychiatric disorder must be of a nature or degree which makes it appropriate for the patient to receive medical treatment in hospital, and serious harm may be caused to their health or safety or that of other people unless the person receives medical treatment, and it's got to be necessary for that person to receive medical treatment. It can't be provided unless the person's detained under the Mental Health Act and appropriate medical treatments available for that person. So those are the criteria that the tribunal will have to consider in each case. So let's sort of think about the issue of a psychiatric disorder. So we're thinking about someone who is detained under Section 3 and their case has come before the tribunal. Well, the first thing the tribunal's got to think about is, have they got a psychiatric disorder? At present, all the tribunal has to be satisfied of is that the person has a mental disorder. And once that box is ticked, once they have heard evidence about that, you go on to look at the nature, the degree of the disorder, and then the risk criteria and the appropriate medical treatment. Now, it seems to me that the new tribunals are going to have to focus a lot more closely on diagnoses when they're considering a Section 3 case. And I can already foresee some very contentious diagnostic issues. For example, there are really sort of very contentious boundaries between diagnoses such as emotionally unstable personality disorder and autistic spectrum conditions. And what if both are present? Which one of those meets that is being relied on, and which one meets the nature or degree test? So, I mean, I can see tribunals really having to look at the detail of diagnosis at a much more granular level than they do at the moment. I can personally see a much greater use for independent expert evidence on diagnosis. And I also wonder whether hearings will take longer. And this has occurred to me as we start looking at some of the other changes as well. And of course, that's going to have relevance for some of the impact that Zoe talked about. Because Zoe, I'm guessing that when you're looking at those tribunals, that extra time for the tribunals, we're thinking about people continuing to have tribunals at the rate of 2 a day, which is how they're normally listed. But I do wonder whether actually that will continue to be realistic, and we'll see a bit more about that as we go through the other changes. I also wonder whether we'll start to see further arguments for specialist panels for tribunals. So at present, the tribunal has a specialist CAMS panel. And if there is a case involving an under 18, one member of the tribunal panel will always be a CAMS specialist. I'm wondering whether we're going to start seeing further calls for specialist panels in fields such as learning disability and autism. So moving on from that, the next big change, as far as I see it, is the serious harm test. So again, currently, when a tribunal is considering whether to discharge someone from either Section 2 or Section 3, they're looking at whether a detention is either justified in the interest of the patient's health or safety or with a view to protection of others? Or in the case of Section 3, is it necessary in the interests of the patient's health, safety, or with a view to protection of others? And if you're looking at the risk to others, the code of practice tells that you've got to look at the nature of the risk that's posed to others, the likelihood of the harm, and the severity of that harm. Now, what are we going to be looking at in future? The serious harm test will apply both to a case to someone who's been detained under Section 2 or Section 3. And remember that the test is whether serious harm may be caused to the person's health, to the person's safety, or to another person. And it's quite clear, looking at the explanatory notes, that the intention of this is to limit the number of people who are being detained under the Mental Health Act in the first place. And therefore, just as it's supposed to make it kind of harder to detain somebody in the first place, the criteria for continued detention by a tribunal are also, the bar is also being raised, in my view. The idea is that unless this serious harm test is met, the person will have to be discharged. And the idea is that that supports the principle of least restriction, which of course it does. And if you remember that the independent review of the Mental Health Act explicitly said, we want these provisions to make it harder for people to end up detained in hospital under the Mental Health Act. And I think that's what this will go some way to do this. So let's think about the arguments that might generate. So first of all, we saw that the new criteria require the detaining authority to show that serious harm may be caused to the person's health or safety or other people. Well, how certain do you have to be? What does may mean? Is it sort of, anything other than fanciful, or does it mean, what's the degree of certainty needed? And what sort of strength of evidence is going to be required to show that serious harm may be caused to the patient or others? Are we going to be moving into the realms of sort of fact-finding, for example? And how would the test apply if you are considering the case of a patient who, for example, continues to experience really unpleasant, quite frightening psychotic symptoms? They're not, but there's no evidence that they've ever acted on them to harm themselves or to harm other people. Would there be an argument to say that those symptoms are causing serious harm to the person's health? Or would that be one of the cases where the principle of least restriction should mean that that person who might now be detained in the interest of their health should now be discharged and should not be being detained? How are we going to get, what kind of evidence will be required of what the alternatives are to detention? So again, I see this as something that's going to require a fairly forensic approach from the tribunal, possibly greater use of expert evidence on issues such as risk. Again, thinking about the impact on the length of the hearings. And then lastly, the therapeutic benefit test. And here I think the changes sort of do bring us perhaps more into step with where the law is going in terms of some of the guidance that we're getting from Strasbourg cases, and indeed in one case, the upper tribunal case. So then this is a change to the test for appropriate medical treatment. So appropriate medical treatment at the moment basically covers, is a very, very broad definition, and it's treatment that has the purpose of alleviating or preventing the worsening of the disorder or symptoms and manifestation. What's changing now is it's got to have a reasonable prospect of alleviating or preventing the worsening of the symptoms, and it's got to be appropriate in the person's case. So it's actually got to have a good chance of making the person better. And whilst that sounds a pretty common sense formulation, but equally you know, that's going to require a demonstration that there is a reasonable prospect of this treatment actually working. And in some cases, that's not entirely straightforward. And just to sort of remind everyone of the case of SF and Avon and Wiltshire Mental Health Partnership, in that case, the upper tribunal said that the first tier tribunal had got it wrong when they found that a patient was getting appropriate medical treatment that wasn't tailored, when it wasn't tailored to their diagnosis, and where the treatment that really seemed essential to that person wasn't available. It wasn't enough to say that the sort of milieu of the ward was kind of aimed at, had the purpose of alleviating the patient's disorder, the symptoms of the patient's disorder. More was required, and I think this change to the criteria does, you know, having looked at what also we saw in the Spivak and Ukraine case, it does seem to be getting us a bit closer to where we're being guided to go by the European Court. But it's going to make a big difference, I think, to tribunals. So this is what the explanatory note says. A reasonable prospect is one where there is a reasonable possibility that the patient will derive some benefit from the treatment. So you don't have to conclude that it's more likely than not that the patient will benefit. And we'll all be pleased to see we're going to get further guidance in the new code of practice. But it seems to me this is going to give rise to a lot of, again, potentially quite complicated and detailed arguments about what actually is the prospect of the treatment that is available for the patient actually doing them any good. And what's going to be the position for cases where patients steadfastly refuse to engage in the treatment that's available? Will it, you know, what's the possibility of it benefiting them if they're absolutely refusing to engage? So again, you know, some very interesting and important questions, quite complicated, possibly going to require more independent expert evidence. And again, I do wonder about the amount of time that hearings are going to take. So asking the question, does it shift the dial in favour of the patient? Well, it certainly is going to require the tribunal to look at a number of very, you know, quite complicated issues, to look at to take a very detailed approach. There'll be a greater role for experts, in my opinion, possibly a greater need to resolve disputed facts. And I do wonder whether the expertise, you know, whether there'll need to be some further capacity building, or there'll be calls for further capacity building in terms of the particular expertise of the tribunal. So that's all I wanted to say. I do wanted to second Liz's thanks to our pupil Jordan, who did helped us a lot with the research for this panel. I hope we've now got a little bit of time to take a few questions, Aswini. I'm now going to stop screen sharing.
Well, that's really, I must say, I found that all extremely interesting. And Sophie, good to see that there is some robust, maybe positive change in terms of the therapeutic benefit test. But it looks like, to me at least, that evidence is going to be the key to these, isn't it? What kind of evidence you can find of serious harm, therapeutic benefit, all of those. Okay, but leaving that to one side, there are a few questions. Some of them I managed to answer in advance, but I'm just going to go quickly to one or two points, quick points, perhaps for Zoe. Managers' hearings, will they change? Are they going to be the same in frequency? Quick yes or no, or whatever.
Mute point in the bill, but I believe they'll increase, not decrease, because of the amount of automatic references you do on renewals.
Right, increase, not decrease on, but they are obviously still a thing, and patients will still have that available to them. And then, of course, we have the $1 million, or perhaps the $1.2 billion question that you were posing. I got the number wrong. I know, do we have resource available in the community to implement these changes? Local CMHTs are already stretched and falling apart. That's Andrew Joseph asking that question. Now, you did give us the numbers, and I read them, and I was listening to you. I thought, okay, so money is being put in the right direction, in the right sort of area. Is it in fact going to land where we need it?
Unclear. I mean, the Parliament did say very clearly that they wouldn't enforce all of these things unless monies were made available for the resources required in order to bring them in. That's the bit that we have certainly responded to as a trust in the call for the last evidence, saying we really do need this to make it a success.
Okay. Now, there's a question here about success criteria as well, and what that might look like for this change, and what would failure look like, i.e. if the changes met their stated presumed objectives, and what would we concretely see happen differently. Then the question goes on, this seems a change where there are multiple problems the changes are trying to fix, but also a risk of multiple types of second order impacts that are not necessarily going to be appreciated. In relation to supervised community discharges, I wonder if the reason this hasn't attracted much attention in the debate is that so much attention has been focused elsewhere. I value your clear explanations of the changes. That's a thank you at the end, I think. But so there are 2 points there. One is really about, are there some parameters by which success and failure might be judged? And then you know, is there perhaps some deliberate obfuscation of the difficulties around supervised community discharge? So perhaps, Zoe, if you deal with the first part, and Liz, can I ask you to think about the second part?
I think with all changes, we can't anticipate always what it's going to throw up. One of the things that lots of people have made comment on, I know I have too, is concerns that sometimes what has been looked at hasn't looked against the systems that we currently work to. So some of the things that they want to continue on within the Mental Health Act, or new bits being brought in, perhaps our resources aren't quite set up to deal with them in the way that we expect them to, and the mechanics therefore don't quite work when it comes in. We see that with every piece of legislation, of course. So yes,
All right.
space.
Okay, so before I get back, so that was the question that we've answered. So there is a question here about dolls and the Secretary of State's role and Section 41. The question is, I think it should read, does that mean that the MOG should consider dolls before imposing a Section 41 condition? What is the I suppose the relationship between the proposed new power in the Secretary of State and Section 41?
Well, the way I read it is that, so of course, the Section 41 order would be imposed by the Crown Court at the point of sentencing. The way I read this change was that, of course, the Ministry of Justice has the power to conditionally discharge the patient as well. I know they don't often do so. It's usually the tribunal that will conditionally discharge restricted patients, but where the MOJ has that power, they would be setting out what those conditions would be on the discharge, and that could include conditions amounting to a deprivation of liberty if the test is met, as we discussed earlier. But I suppose the answer is they ought to be looking at what the other conditions are that are being recommended by the clinical team before thinking about whether or not those amount to a deprivation of liberty, rather than the other way around, rather than thinking, do we need to deprive this person of their liberty in the community, and if so, what are the conditions? I think it ought to be, what are the conditions that are needed, and then do those amount to a deprivation of liberty?
And can I just say something else on that topic, which I really agreed with you, Liz, looking at the possible unintended consequences and the mission creep that this provision could generate. Just remember what we were all told about CTOs. They were going to be for a very few intensively unwell people who are kind of revolving door patients. Within months, the use had vastly outstripped all estimates, and it still does. And I have real concerns that those provisions might become sort of go-to conditions as opposed to exceptional circumstances.
Standard
Yeah,
conditions.
I agree.
So what about the point that I asked about earlier, which is all about the distraction from supervised community discharge in the debates, and whether why it hasn't attracted much attention? Do you have any thoughts about that, any, Liz or Sophie?
I think it probably wasn't felt to be that controversial, because there's quite a clear gap in legal framework here, and that seemed to be the fairly obvious way of filling it. But maybe it isn't. It isn't getting the debate that it needs, because maybe the government hasn't quite clocked that it could actually affect a larger group of patients, as Sophie has just said, you know, as it happened with CTOs. So it probably does need a bit more attention, because this is a really significant power that tribunals and the MOJ is going to gain.
Right. Okay. I'm going to read the last question. It's from Peter Beasley, and it's basically making a comment on the presentations, but also offering some information. I don't know how we get that, Peter, but what he says is, I agree entirely about the point being made about overlaps between conditions and the new need for the tribunal to focus on these issues. This is exactly right and on point. The breadth of the autism, in quotes, legal diagnosis will mean that conditions other than autism will be unintentionally excluded. I would argue the definition as written could equally apply to personality disorder, for example. We will have people making, in quotes, my personality disorder is autism type arguments. If it's any help, and then there's a recent paper published, which he points to there, which we can, I'm sure, make available if appropriate. But I mean, I guess what he's just, does anyone want to comment on that in terms of sort of, I mean, I guess it's what you were saying, Sophie, there's a lot of scope here for arguing about psychiatric diagnosis, what's in, what's out, and it is now a whole, shall we say, it's a can of worms opening up.
Well, yeah, I mean, it's not, it depends how you look at it, but it's certainly going to require lots of really careful diagnostic examination by tribunals that at the moment don't always have to do that. So yes, so I mean, so I agree. I agree with a lot of what's said in that comment. Okay.
So here are some other questions. Thank you so much for answering that. And thank you for that question as well. So nearest relative discharges and barring, I suppose that's not quite tribunal, but it's not quite what we were talking about, but a quick answer to that, if possible, that's all remains, doesn't it, as currently?
Pretty
more or less.
More, yes, it does more or less, actually. I think, and the nearest relative, well, of course, the nearest relative is going to be replaced by the nominated person. The nominated person does actually have a few additional rights that the nearest relative doesn't. There's a bit more consultation before a CTO is put in place, still has the discharge powers, also will have the power to make a formal request for a care plan to be reviewed. So quite a few general changes, actually, in the nominated person that we did look at briefly in our opening seminar back in January.
Okay. Now this is, we're a little bit over time, but I think this is the final question, and it's really about serious harm and the serious harm test, which is now a third limb essentially to the admission and discharge criteria. And I mean, just trying to follow your explanation of the new risk criteria, let's call it, it's quite convoluted, isn't it? And is there any guidance going to be offered on that? Is one.
Yes, according to the explanatory notes, there's going to be guidance on this in the new code of practice. Right. So we'll wait and see what that is. But it is quite complicated, and because you could interpret it in all sorts of ways on a spectrum, from exactly the same as it is at the moment, i.e. it's necessary, or something, you know, a real tightening of the criteria. So it'll be interesting to see what's in the code of practice, and I think it's going to be a real area for, you know, legal discussion and debate and eventually clarification, probably through the upper tribunal at some point.
Okay, now
who knows?
There is a question here that's really brilliant. There's a question here, which I think we've already touched on in terms of the funding for not just the whole system, but certainly the system, the care and home less restrictive options that are going to be needed to be alongside detention, because I think you were all saying the aim here is to reduce the numbers of people subject to detention. Now, the question was, is additional funding earmarked for less restrictive provision? I think you've answered that already. Wasn't really possible to identify, Zoe, is that right?
No, I mean, it would probably just sit within the general figure that you've seen, that the money's going to health and to social care. I don't think any particular service has been earmarked for funding in that way. It's a generic scoping, so it comes into scope, but it's not specific.
Yes. So I think a point that I think was made is that there's a risk here, isn't there, that a number of people who need treatment and care might fall outside of the provisions that might provide treatment and care. If they need it in hospital, for example, they won't be getting it. That's a difficult one, because we know that that plays in so many directions for people who want their rights to be protected, but there might well be a group such as that.
Absolutely, and I do hope that the government hears that, because when we look at cases such as Valdo Calocane, we know that there was no assertive outreach team available to him. So this is quite a hot topic, I think, and they do need to think very carefully about what provisions are available in the community, particularly in time of crisis, if there are going to be people who no longer meet those criteria for admission to hospital.
Brilliant. And we know it's already a problem, isn't it? You know, but those of us who sit on the tribunal trying to discharge patients into a care package or home, I mean, it's a trial, and we have to be quite creative sometimes in the use of the powers that we already have to try and flesh out what's available. But it's already a crisis point, so what's needed is going to be significant. So that's a good point to end on, I think. We want the government to hear what we've said about resources. We're not alone in this plea. Let's make it realistic and make this work, but we need to have those provisions properly funded. So with that, I'm going to say, let's come to an end. Thank you very much. I think that's been a quick trot through some very complicated stuff, but lots of very thought-provoking information. Thank you very much to the three of you. And thank you very much to everyone who joined today. We've had some lovely comments already saying thank you for the informative webinar, so I'm sure that's lovely to hear. Thank you to those who helped to manage the screen and put this on, and also once again to all the work that you've put in to make this happen. So with that, thank you very much. We'll draw this to a close. Good night.
Thank you, everyone. Bye-bye.
Thanks, Aswini. Thanks, everyone.
Thank you.